Hi, and welcome to session 8 of the Human Resources Management Training Program. So I'm Charlie Domville-Lewis, and I'm the Senior Education Officer from the Department of Commerce. Now, if you've been following the series, which I'm sure you have, we've been going through various areas of employment law. Now, we've been looking at very specific things recently, and now we're going to look at the basic entitlements that all employees in the state WA system have. We're going to be looking at the Minimum Conditions of Employment Act. So this is the safety net legislation that sits below all employees in WA, and it sets the very bare minimums that all employees can expect. So we're going to go through what those entitlements are and some of the areas that aren't included in that, but you should still be aware of. So firstly, we're going to look at minimum rates of pay. So there are certain requirements towards pay that you must be aware of as an employer. Firstly is the requirement to be paid for every hour. So this means that an employee, as soon as they are required to be at work, they have to be paid for that time. You may have seen a couple of sessions ago, I went through the case of a jewellery chain that wasn't paying employees and had to back pay about $86,000 because they weren't paying people for an hour shift because they were requiring them to come in early and not paying them for that time. So it can be a very serious thing if you don't apply with the payment for every hour requirement. The other one sounds like a very basic requirement, but it's something that you'd be surprised how many people get wrong. And this is the requirement to pay employees in money. That means that an employee cannot be required to accept anything other than money as a remuneration for their time. So you can't require someone to work for food or accommodation or anything like that. That cannot be taken out of their minimum entitlements to pay. That's something that actually happens more often than you think, and it's very important to be aware that you can't do that. That's actually a breach of the Minimum Conditions of Employment Act. The other requirement as to minimum rates of pay that you've got to be aware of is deductions have to be authorised. So that means there's a few different areas to be aware of in terms of what an authorised deduction can be. Firstly, you can't take any money out of someone's pay without their written consent. For example, we often see in various industries, if someone damages something as part of their role, that they have that money taken out of their pay without any consent. But that's actually illegal to do. An employee could claim that money back. You have to get their written consent to do so. The other area to be aware of is obviously areas that are authorised by legislation. So things like taxation, that's technically a deduction from someone's pay, but because legislation requires the employer to do it, there is that considered to be that authorisation by legislation to do it. So those are the two areas to be aware of. There's the employee's consent and also legislative consent, the consent of the law to take that money out of that pay. So to sum up, the requirements to pay for the Minimum Conditions of Employment Act are that an employee gets paid for every hour that they're required to work, that an employee has to be paid in money and not in goods or services or accommodation, and that any deductions from someone's pay has to be authorised by either the employee themselves or by legislation that allows the employer to take that money out. Moving along, the next area that the Minimum Conditions of Employment Act deals with is leave requirements. So this is time off that an employee can take while they're working. So for a full-time or part-time employee, you've got personal leave and annual leave. Now, personal leave can be used in one of two ways. One is as sick leave. If the employee gets ill or injured, they can take time off and be paid for that time while they recover. The other area to be aware of, which a lot of employers aren't aware of, is carers leave. So this is employees' right to use their sick leave to look after a dependent in their household. A dependent can mean, say, an elderly relative or a young child. If they fall ill suddenly, an employee has to take time off to look after them. They can take those hours out of their sick leave and still get paid for that time. Both in the case of sick leave and carers leave, it's important to be aware that an employer can often require that the employee takes reasonable evidence to show that they were actually entitled to take that time off. I'll just mention now, if you've got any queries about any of the issues that we talk about today or in any of the sessions that we've done over the course of the last few months, you can email them to westlink@rdl.wa.gov.au. Any queries that you have about employment law will then be forwarded to me and I can get in contact with you and hopefully answer them for you. The other area that the other leave entitlement that employers have to be aware of under the minimum conditions is annual leave. So this is holiday pay. This is time that an employee can take off and do whatever they wish to do with. Now, in terms of personal leave, that will be 10 days for every year that an employee works if they're full-time. For annual leave, it's 4 weeks for every year that they work. In terms of whether an employee can cash out that leave, it's only under the minimum conditions that they can do so. So if an employee wants to cash out their annual leave, please do call WageLine and get some advice on whether they are actually allowed to do so in that particular instance. It's quite important to check that. There are other requirements to leave that the minimum condition specifies. One is public holidays. So this sets out all the public holidays that Western Australia has, and it sets out the fact that if an employee is not employed on those days, solely because it's a public holiday, then they still get paid for that time. That applies to full-time and part-time employees, but not casuals. Again, if you've got any queries about public holiday, about working on a public holiday or not working on a public holiday, do call WageLine or send us an email at westlink@rdl.wa.gov.au. Another area that the minimum conditions deals with in terms of leave requirements is bereavement leave. So this is time off an employee can take if someone in their household passes away and they need to attend a funeral and things like that. They get 2 days of paid leave per instance. So per instance means per relative that passes away. Another thing to be aware of with bereavement leave is that casuals can also access it. So unlike annual leave, personal leave, and public holidays, a casual can actually access bereavement leave if a relative passes away, unlike the other kinds of leave which are only available to part-timers or full-timers. And finally, there's parental leave. Now, parental leave under the minimum conditions is an unpaid entitlement. So some of the areas that you've got to be aware of is that an employee will get 52 weeks of unpaid leave if they adopt or give birth to a child. This can be then split between the couple, so both the person giving birth and their spouse. The requirements for the employee are that they give 10 weeks 10 weeks notice to their employer that they require to take this leave. Again, it's an unpaid entitlement, and the employee must have worked for at least 12 months at the point that it arrives, at the point that the child arrives, to access that parental leave. So again, that is something that can be split between the couple. And the other thing to be aware of with parental leave is that the employee can actually make an application to extend their period of parental leave. So they can access another 12 months on written application. That will then be up to the employer about whether they grant that, but always seek some advice about whether you will be required to provide that extra leave. So just to summarize, we've got the requirements for leave under the minimum conditions are personal leave, so that's leave that either can be used for sick leave or carers leave. Annual leave, so that's holiday pay. You've also got public holidays, bereavement leave, and parental leave. And the other kind of leave to be aware of is long service leave. Now, I'm not going to go into too much detail on that today because it's a very complicated area and we're going to do a whole session on it a bit later. But you need to be aware that of certain things that are required with long service leave. Firstly, it is required by all employees, so full-timers, part-timers, and casuals. If a casual works for long enough, they're going to get long service leave. The basic entitlement is just over 2 months, 8 2/3 weeks, after 10 years. But an employee can access it after 7 years if they leave the business or the business terminates them. They get a pro rata payout. That's about all I'm going to talk about with long service leave today, but it's very important to be aware that that is a requirement for you as an employer. And as I say, we will cover that in greater detail in a later session. Okay, so moving along, we now have the other area that the Minimum Conditions of Employment Act deals with, and that is what's called redundancy and significant effect. What that means really is the steps that an employer has to follow if they are going to make that employee redundant, or they're going to significantly change the job that the employee does. So they're going to significantly reduce the hours, they're going to significantly change the responsibilities of that employee. It sets out the steps that the employer has to follow. Now, I'm not going to go too much into redundancy today because it's quite a complicated area, and it's really best to get advice in any specific industry, any specific instance. But the things to be aware of is that the employer has to inform the employee that they're either going to be made redundant or have their job significantly changed as early as possible, or as early as practical. The employee has to be aware of, as soon as the decision has been made, basically by the employer, that they have to either make that employee redundant or change their job, the employee has to be informed. The other thing to be aware of is that the employee can now access paid leave for job interviews. So that is 8 hours of paid leave in their notice period that they can use to attend job interviews. So it's very important to realize that both they can access that as a full day of work, or they can access it as 8 individual hours. That will be a paid entitlement, and they can use that only in the instance that they have a job interview to attend. So just to sum up, if an employee is to be made redundant or have their job significantly altered, an employer has to inform them as early as possible, and they also have to give them paid leave to attend job interviews during their notice period. The final area to be aware of that's dealt with by the Minimum Conditions of Employment Act is the record-keeping requirements. So this sets out both your requirements to record details about your employee, and also how long you have to keep it for and who you have to make it available for if that is a request made. Now, there will be a whole session on record keeping a bit later in the series. So here's just a brief overview on this slide that you're looking at now of the record keeping requirements. For each employee, you've got to keep their personal details. their commencement date, so when did they start with the business, the amounts that they were paid before and after tax, their start and finish times and any meal breaks for each shift that they do, and details of all deductions that you make and what they were for. Apart from that, also any leave that they take from the business, whether that was paid or unpaid. There are actually templates available on our website that you can access. So a lot of businesses use things like MyOb or QuickBooks to record their employees' details, and that's fine. The only thing about those is that they weren't designed with the legislation in mind, whereas the templates that we put on our website, they were. So even if you don't use our templates, I think it's very useful to have a look at them and make sure that you're kind of recording everything you have to. The other things to be aware of with record keeping are certain requirements that you have in terms of how long you keep them. Every record must be kept for at least 7 years. A lot of people think it's 5 years, but that's the tax office's requirements. Under employment legislation, you've got to keep it for at least 7 years. An employer must make an employee's records available if a relevant person makes a written request. So who's a relevant person? That could be the employee themselves. That could be an employee's representative. So that could be, say, a union representative or someone's lawyer, or an industrial inspector. Now, industrial inspector are the investigators from our department. If we hear about a breach, it's the industrial inspectors who will go out and investigate that breach and see if there has actually been an underpayment. And that's really why it's very important to keep good, clear records, because they're the thing that's going to protect your business. If someone makes a false or misleading claim against your business, if you've kept very clear, very thorough, very concise records, that's very easy then for you to demonstrate that you have complied with the law, because that's the first thing that we're going to look at from our department if we do hear about an underpayment of wages or any entitlement under this legislation. All right, well that basically covers it for today's session on the Minimum Conditions of Employment Act. Just to reiterate, we've gone through the minimum requirements in terms of pay for employees. We've gone through all the leave requirements that you have to be aware of for all employees. What you need to do if you want to make an employee redundant or significantly change the job that they do, and also your requirements with regards to record keeping. So if you have any queries about that, you can always call WageLine. It's a free, confidential and unbiased service. So you can call them, get some advice and make sure that you're covering all the areas that you have to. So just to reiterate, that is entirely confidential information. A lot of people worry that if they call WageLine and confess to some unknowing wrongdoing, that it's going to, a black van is going to turn up and take them away to bad employer prison. But that isn't the case. It's going to stay between you and the person that you talk to, and you can move on from there. And obviously you won't always get the answer that you want. You won't always get good news, but you will know and you can move on from there. And I think that's the main thing. So just to finally say that this has been a very general overview only, and you should always seek specific professional advice before acting or not acting on the information on this presentation. So in the meantime, if any queries come up as a result of today's session or any of the sessions that we've done, please feel free to either contact WageLine or email westlink@rdl.wa.gov.au. Thanks a lot, guys.